Modern Real Estate Practice, page 112. When a person dies, ownership of real estate passes to the co-owner by virtue of a joint tenancy with right of survivorship, or a tenancy by the entirety. The party or parties named in a valid will, or the statutory heirs determined by the state's law of descent and distribution. Title to property held in joint tenancy with right of survivorship or in tenancy by the entirety needs no court action for title to pass, but the death certificate should be filed so that it becomes part of the record of property ownership. When title passes by will or descent, the estate must go through a judicial process called probate, in which the successor to the property title will be recognized. Usually, claims against the estate must be satisfied by the designated individuals can take possession of the property. The party named in a will could be the trustee of either an existing trust or a testamentary trust established by the will. Transfer of title by will. A will is made by a property owner to convey title to real and personal property after the owner's death. This type of property transfer differs from a deed, which must be delivered during the lifetime of the grantor and that conveys a present interest in property. While the testator, the person who makes a will, is alive, any property included in the will can still be conveyed by the owner. The parties named in a will have no rights or interest as long as the party who made the will is alive. They acquire interest or title only after the owner's death. Only property owned by the testator at the time of the testator's death may be transferred by will. The gift of real property by will is known as a device, and a person who receives real property by will is known as a devicee. The will can also include a bequest of a legacy, which is a gift of personal property. For title to pass to the devicees, state laws require that on the death of a testator, the will be filed with the court and probated. Probate is the formal judicial process for verifying the validity of a will and accounting for the descendants' assets, and is discussed below. The process can take several months or considerably longer to complete before the estate is settled. A will cannot supersede the state laws of dower, courtesy, and homestead, which were enacted to protect the inheritance rights of a surviving spouse in certain real property owned by the descendant. In most states, the surviving spouse is further protected by a statute that provides for certain personal property of the descendant to go to the surviving spouse, if the will does not provide the minimum statutory inheritance. In either case, the surviving spouse must decide whether or not to contest the will. Legal requirements for making a will. A will must be prepared and executed according to the laws of the state in which the testator resides. If the testator owns property in any other state, the will should also comply with the laws of the state in which the real estate is located. A testator must have legal capacity to make a will. There are no rigid tests to determine legal capacity. Usually, a person must be of legal age and of sound mind. Legal age varies from state to state. To demonstrate sound mind, the testator must have sufficient mental capacity to understand the nature and extent of the property the